I'll just repeat, my name's Kline Williams. I'm the founder and chairman of New Era ADR. If you guys all notice, I'm looking up because my big screen is up here. So it's not that I'm not looking at the camera, but we're really excited to gather everybody here today. We have a phenomenal speaker, Joe Alfe from Texas A&M. He's doing some really interesting stuff in the Title IX space with dispute resolution, informal resolution, mediation, all sorts of cool things that he'll explain. So just a few housekeeping things. We will do Joe's introduction. We will have a question and answer session. And then we will reserve the last 15 minutes to actually answer questions that you guys may put in the chat. So as we go, if you've got stuff that you want to get answered, please put that in the chat. We'll do our best to get to as many questions as possible. We will send out sort of a Q&A for anything we don't get to make sure that everybody's questions do get answered after the webinar. And then actually at the end of this whole thing, after the end of an hour, we're going to have a networking portion of this. So we're going to leave the Zoom open and you guys can talk amongst yourselves. You can meet other Title IX professionals and we'll let that go as long as it seems reasonable to do so. Just to give you guys, so you understand what New Era is, New Era ADR is a technology company and we create platforms and solutions that make dispute resolution easier, more efficient, and really most important, more accessible and significantly less expensive. So our technologies include a full Title IX platform. We do informal resolutions, and we have a full bench of trained facilitators that actually handle that. So everything from beginning to end, and the entire process is virtual, so you never have to go anywhere. If you want to learn anything more about this, please contact me directly. It's Kline, 2 L's, at neweraadr.com. So at this point, I want to get to what you guys are all here for. I'm going to introduce Joe. So Joe earned his Juris Doctorate from the UIC School of Law. I'm a Chicagoan, so I really appreciate this. It's formerly known as John Marshall for anybody who are familiar with the schools in Chicago. He also earned his Master's of Law in Dispute Resolution from the #1 ranked Strauss Institute of Dispute Resolution at Pepperdine Caruso School of Law. Some of you guys are probably familiar with it. It's an incredibly interesting program that's doing amazing things in ADR. So prior to his career in academia, Joseph was an entrepreneur and a mortgage lending executive. He also teaches dispute resolution as an adjunct professor of law and has nearly half a dozen articles published in various legal journals, including recently proposing a new form of dispute resolution that we will talk about that's specific for higher education institutions. And that article that he actually wrote about this is in the Pepperdine Journal of Dispute Resolution. Personally, some interesting things about Joe: he enjoys bass and fly fishing, collecting gems and minerals. That's something we could probably do a whole webinar on our own. Biohacking health and fitness. I definitely would love to hear about that, Joe. And spending time in the outdoors with his wife and 5 kids. As a person with 1 kid, I can only imagine what 5 is like. So Joe, thanks for being with us. We really appreciate you being here and really excited to hear what you have to say.
Thanks, Kline.
So before we get started, I would just like you to describe your informal resolution process, because there's a lot of unique things that you do, but also to give us some context. And I also like you to explain this because I understand the way that you facilitate these things may be very different than how other people do it.
Sure, thanks. My name's Joseph Alfe. I'm here at Texas A&M University. And some of you may have heard me speak at a TICSA, so you have a little bit of an idea that I might do things a little bit differently. Before we get started, I do want to make like a little bit of a note here that if I do use traditional she and he pronouns, it's just for ease of description when I'm talking about something. It's not synonymous with who complainants generally are, complainants or respondents, and it's important to understand that the parties can and will span all genders and identities. So I tend to take a more active approach to facilitation. I default to remote and shuttle facilitation. I think that helps foster a sense of safety and comfort with the parties. And it also creates a confidential and safe space when we're in breakout rooms. And I think that helps lessen the anxiety and fear, and it promotes communication. And it also, I think, helps when there's advisors present. I think it just helps frank conversation. Part parties aren't afraid to be seen or heard or see or hear another party. So I think it just helps keep the anxiety levels low. So my process that might be a little different is that rather than trying to, and I'm going to use the word mediate intermittently with facilitate, so don't read anything into it. It's just for ease of conversation, but I mediate the resolution rather than the allegations themselves. And so in other words, we don't try to prove the facts or find out what may or may not have happened, because I feel that's what the formal process is for. That's where we discuss differences in the formal and informal process, and the fact that we're dealing with allegations and not proven facts. So I put it this way: the formal process starts from today and it looks backwards. This is where somebody will tell their story and prove their case. They get the full due process. The flip side to that is that the formal process is lengthy. It can be coercive. Parties have little control over the outcome. So conversely, with the informal process, we start from today and we look to the future to a resolution. So the parties are empowered to make their own decisions and their own agreements, and they have full control over the outcomes. I don't make any decisions for anybody. They make their own decisions. And since we're not really here to find out or prove what happened or didn't happen so much, we just take the allegations at face value and explore ways to move forward. And I think this allows complainants to choose whether they want to take a punitive approach or a restorative approach or some combination. It allows parties to be more creative with the options that might not be on the table in a formal process. So we really try to get down to needs and wants versus just finding out cold hard facts. So really that's the basis of what I call the 2 + 2 = success formula, which I could spend 2 hours on its own webinar with that. So the takeaway is empowerment, creativity, but that also comes with a price. So both parties have to be aware that both parties must agree. We can't make one side do anything. So that often means that there has to be flexibility and compromise. If a party's not willing to do that, then maybe the informal process isn't for them. So we have a very good team of case managers who really set up the process and go over the differences between the formal and the informal process with them. So by the time they get to me, they understand how it's going to work, and they're ready to look forward towards a resolution. If it's not for them, that's okay. They can go back to the formal process at any time. And I tell that to my parties as well, that nobody's making them finish out an informal session. If they feel like it's not working for them, we can go right back to the formal process. And in the informal process, I think there's a misnomer out there that justice isn't done, that they won't get the same outcomes as they would in a formal process. And that's just not true. Responsibility is often taken, and oftentimes there's agreements for punitive sanctions. Some of them are quite life-changing, to be frank. But it's by mutual agreement, and that's really the difference here.
Yeah, I find it really interesting you say that, because coming from a litigation background, that was always, I would have clients that thought, I'm going to go through this litigation process and I'm going to win. And you always had to counsel them. There's not a whole lot of justice in the legal system a lot of times. And you can actually find much better resolutions that feel much better by doing something that's informal, going through a mediation process, coming to some sort of resolution by agreement, rather than duking it out and thinking that at the end of the day, you're going to have some cathartic moment where you raise your hand and say, I did it, because that almost never happens. But this is great. Thanks for the background. As everybody knows, this webinar is about the psychology of dispute resolution and empathy in the process of informal resolution. So we're going to get to some questions that center around that stuff. But as we lead into that, I really want to ask just some background questions of Joe, because even Joe mentioned, he went to law school at 45, so not a traditional route. So I'd just like you to tell us a little bit about your background and how you got into the world of Title IX.
Yeah, I went in to law school as an older student, so I kind of had some life experience to take with me. I was very interested in the academic side of legal education. My passion is constitutional law, so I took every single possible course in con law. I was in the International Human Rights Clinic for 2 years. Most of my published scholarship has been on constitutional law, and civil rights and constitutional law and Title IX fit together, of course. I actually was introduced to Title IX when I took a deep dive, because I had gotten a Title IX fact pattern for a national moot court competition that I was in. So that bit of research really led me into the Title IX world, and I just kind of resonated with it. So that's why I decided that when I got out of law school, I knew I wanted to go into higher education and teaching, and it just was a natural fit with Title IX.
So as you've gotten into this world, I can combine this a little bit. It's 2 questions, but what do you enjoy the most? And hopefully this will resonate, because there's a lot of Title IX professionals on here, but what do you enjoy the most about working in Title IX, and what do you find are the biggest challenges?
Well, I'm not a very routine oriented person. So I don't know, maybe it's my ADD or whatever, but I always have to have rapidly changing scenarios to deal with. So as anybody who's in Title IX knows, there's never a dull moment. It's always something new. So that really I think keeps me interested in the day-to-day things that we see. It's just constantly changing. And also getting into higher education and getting into Title IX, I mean, how often do you get the opportunity to put some of your theories into practice? So that was very attractive. And then from a personal standpoint, as a father, I have 3 daughters, and I also have 2 sons. And I see them in every complainant and respondent that I deal with. So it really does affect me in a personal way, where I see these oftentimes young people, and the consequences of maybe some poor decision making. And so it really gives me a I don't know, just like a protective where I want to do good for these people, no matter what side they're on, and no matter whether or not that there's going to be some punitive outcomes or not. It's still a teaching moment, I think, and it's still an opportunity to help somebody make decisions that are going to hopefully benefit them in the future.
Yep. One question, just briefly, I have about your background is you mentioned you went to law school. Do you think a law degree helps or hurts as a Title IX professional? And there's a million ways that question can go, but I'll leave it open, and just obviously my background is a lawyer, and you're a lawyer. So I'm just curious whether or not you think that background is helpful or actually can hinder what you do as a Title IX professional.
Well, a law degree is certainly not a requirement. I do think it may help in terms of looking at maybe the bigger picture as far as an institution's risk management is concerned. It also, I guess, helps me work with attorney advisors that some parties bring. But it's, other than law school really teaching you how to think in a more logical fashion, I wouldn't say that it's a great advantage or a disadvantage. But and that also, if I wanted to go back and answer your last question about what the biggest challenge is, sometimes a challenge is working with an attorney advisor that comes in with a little bit more of an adversarial stance. And so I think having at least some legal training helps me talk them into a more collaborative view, because it's sometimes hard to watch young people make these kind of mistakes and reap consequences and experience trauma. And so we don't really need to be in an adversarial space to do that. I don't think that's productive. So really trying to keep more onto the collaborative side of things, I think, is an advantage here.
I would love to have an entire webinar, or at least a sidebar, to discuss what you've seen attorney advisors do in your practice, but that would take too much time for today. So
well, they've been overwhelmingly, it's been overwhelmingly positive dealing with attorney advisors. I will say that. I've been pleasantly surprised with 99% of them.
That's awesome. That's good to hear. So let's get into the practice. I know you've written, and really the crux of this webinar, I know you've written and spoken about the psychology of a Title IX dispute. So this is going to be a pretty general question, but what particular psychological issues do you believe are at the forefront of any Title IX dispute?
Well, I think I don't think it's a matter of psychological issues per se. I think it is the psychology of dispute. And that's an important distinction. We're not looking at somebody did something or did or did not do something because of the way they are personally in a psychological sense. I think the psychology of dispute is what we're talking about here. So in the course that I teach, I include psychology of disputes. What's the nature of conflict, how to recognize and deal with personality types, how to deal with high conflict individuals. Cross-cultural disputes is another big thing. Apology and forgiveness, I think, is very important. Negotiation is in there as well. All these things come into play with informal resolution, and I think those are the things that build the basis of the psychology of disputes.
Interesting. So you've mentioned a lot of things here. How do you deal with these issues at the beginning of the dispute and as that process plays out?
Well, we can open up a huge, rabbit hole with this, but
we'll try to stay out of the rabbit hole. Yeah.
Right. I mean, I have an entire 13-week class devoted to this, but I guess recognizing these issues early allows me to address and overcome them. For example, being at an institution with a large international student population, cultural issues oftentimes come into play. Recognizing these differences allows me to help parties with what I call perspective shifting. Recognizing the other is really what it is. And those differences can often lead to friction between students because they don't necessarily understand where another is coming from. I think it just helps with a better understanding of how a resolution may be possible when you get parties to start taking the perspective of the other. Now, obviously, this doesn't always work. It depends on what type of allegations we're dealing with. I mean, we're not always dealing with what we traditionally think of as a Title IX, let's say sexual assault, is going to be very different, of course, than with a civil rights complaint, maybe offensive conduct towards somebody's religion. I mean, we deal with such a wide spectrum of cases, so it's important to keep that in mind.
So that raises a really interesting question for me, which is, can you give some examples of how you've seen some of these things play out in your practice?
We've had a couple of interesting ones lately, and unfortunately, I missed the Atixa talk when I was in Orlando, but they had one about Title IX and dealing with people that are on the autism spectrum. And I've had a couple of cases that dealt with people that were on the spectrum. And one of them was a stalking case. So it turns out that the respondent was on the spectrum, which this person freely shared with me. And, you know, that can lead to some very tough situations having to do with social awkwardness and behaviors that are outside of maybe accepted norms. And so with the respondent's permission, I was able to speak with the complainant about this and help her shift her perspective. It didn't excuse the conduct, but this new perspective allowed her to choose a more restorative rather than punitive outcome, while still obviously maintaining what she felt was necessary for her safety and well-being on campus. But that's a good you know, example of something that maybe is out of the norm. Another case was between international students and we were dealing with certain cultural beliefs and norms regarding personal honor, aversion of public embarrassment, saving face, however you want to call it. So we had to really work through those issues before we could get them in a space to where they were amenable to talking about a resolution. And the students were from a particular culture, which I call a high context culture, meaning high context cultures communicate in indirect ways, whereas Western societies, we're very direct with our communications. We tend to say what we mean. In high context cultures, they don't communicate that way. In other words, you have to read between the lines, so to speak, to peel the onion and find out what's really going on and what they really want and need out of something like this. So that was a challenge.
Interesting. So more generally, when we look at a dispute and you think of the world of a complainant and a respondent, when a Title IX dispute is initiated, what are your biggest concerns? Psychological, we can use that word, I guess, as an adjective. But your biggest psychological concerns for a complainant who's saying something happened, and a respondent who may be saying, no, that isn't what happened. So you there's a big dichotomy here, right? But there's obviously clear concerns for these folks if you're a complainant or respondent. So how do you deal with those things?
Well, I think, you know, most importantly is to be trauma conscious. Some of these cases are cause for great suffering and anxiety. And that goes for respondents as well. There's oftentimes anxiety that has to be addressed. And I think that's where, you know, like the topic of our talk, you know, empathy and compassion, I think that's where that really comes in. But I think ensuring that parties are going to be heard in any conflict, whether it's Title IX or not, a basic human need is to be heard. And so by ensuring that and really letting them know that you are here to listen, I think by making those points early, you're not only going to listen, but you're going to be without judgment. You're going to be fair in your dealings. I think that's important. And I think parties, you know, they come into these things with a certain amount of anxiety. They assume sometimes that they don't, they come in assuming that maybe they're not going to be listened to or they're not going to get a fair shake. So I like to make the point early that everybody's going to be heard, there's going to be respected, they're going to be listened to. And even though the outcomes may not be, or maybe they will be, we don't know how they think it's going to turn out or maybe how they want, it's still going to be something where they're going to be able to talk. And I think by addressing those things early, it's been my experience where you can physically see the anxiety start to drop away. You can see them getting more comfortable, because it's a scary thing. I mean, they come in thinking, oh my gosh, what's going to happen to me? So once you get talking and make them feel comfortable and make them feel like, they matter, it makes a big difference.
So this is sort of the perfect foray into the conversation about empathy. So it's always been my understanding that the intake process for a Title IX dispute can be, for lack of better terms, maybe mechanical and cold. So how do you make sure that empathy is part of the process from the very beginning of the initiation of the dispute?
I can't answer for how other schools do it and whether or not it's clinical or cold or however you want to describe it. But I know that our civil rights team here at Texas A&M, they're all rock stars. They all care very, very much about conducting these cases with compassion and empathy and professionalism. We have 4 case managers, we have 4 investigators. They're all trauma informed and trained. They do an excellent job of supporting the parties. So by the time they get to me, oftentimes they have a good idea of what to expect. They're ready to engage. They're excited about the prospect because it's been explained to them in detail, the differences between, their options of going through a formal process versus this. But, sometimes we get somebody who's particularly maybe emotionally fragile or particularly anxious. They're not sure if they want to try the informal process, or sometimes we have case managers who will say, this person told me they absolutely, positively do not want to go through the formal process. They don't want to subject themselves to it, but they're also afraid of the informal process because they're not sure what to expect. So sometimes I will do what's called what I call like an introductory phone call or Zoom meeting or something like that, where I can try to put them at ease and explain the differences between the formal and the informal process, explain that they're important, they'll be heard, that, all the things that we just talked about, and that it's a confidential space. I explained to them how I keep everybody separate via the shuttle process, and that they aren't going to be seen or heard or see or hear another party if they don't want to. Now, if parties want to be together face to face or even in a live situation, we can do that. But I default to the shuttle for safety reasons, and a lot of it's psychological safety. So once I explain to these anxious individuals, oftentimes they'll come back to the case manager and say, you know what, I feel much better. I'd like to try informal. And also we tell them that, this is voluntary. No one's making them do an informal. If they get halfway through an informal and decide that they don't like it, we can stop. They can go to a different process. Just again, oftentimes when you talk to these students beforehand and they're very anxious, they're very emotionally fragile, by the time we're done talking to them, you can see the anxiety start to ratchet down a little bit. And I find that when those students actually come to the informal process, they're in a better space. And I think that makes a big difference.
So I'm curious, just from a very macroscopic standpoint, can you talk about why empathy is so important in these disputes?
Well, I mean, empathy creates connection. Connection creates trust, and trust allows for engaged communication. The root of all dispute resolution is communication. So if we're not in a space to communicate, then you're already behind the 8 ball. Plus, it's just the right thing to do. We can't forget the human aspect of Title IX, no matter who they are, complainant or respondent or other party. They're human beings. They have feelings, they have fears, they have anxieties. And using compassion and empathy is so important and goes such a long way to getting the parties in the right mind space to engage in a resolution. So I think that is super important. We can't hope to get people together in a stressful environment like this to talk about resolution if we can't get their mind in the right space to communicate.
Sure. So it sounds like at Texas A&M, you guys have a pretty fulsome intake process, and that you're given a fair amount of information as the actual facilitator going in. But I assume that a complainant entering your office, to actually start the process is scared, worried, concerned. You've talked a little bit about this, and a respondent feels the same way. So you have that introductory information that says this person may have predilections towards XYZ. Maybe they seem more anxious than somebody else. As you enter the process and actually start the facilitation, how do you handle those emotions as you go?
Yeah, well, I work closely with my case managers. So, a complainant gets a case manager, respondent gets a separate case manager, and I'll go and meet with them and say, how is this person? What are your thoughts? Sometimes they come to me with a concern saying, oh, this particular person is very emotionally fragile, or they're very angry, or whatever it is. Everybody's different. Some people come into the process very clear-minded. They know exactly what they want in order for them to move forward. Others are all over the place. They have no idea. And so I just rely on my team to really kind of give me some background. And then I just, again, using those opening techniques to use empathy and communicate that they're going to be heard and that they're in a safe space to combat any overwhelming feelings of anxiousness or fear. Sometimes a party might feel intimidated because they don't have an advisor, but the other party does, because in informal, we don't require an advisor. We allow students to bring an advisor, but we don't require it, and we don't provide one. In a hearing on the formal process, that's different. If they don't have an advisor, we give them one. But sometimes there is a feeling that one party might be intimidated. So that's where that pre-session phone call is helpful, where I can explain that I'm keeping everybody separate and that they're not going to, be ganged up on or we want to manage expectations, I think is the appropriate term. We want to explain how things work. And once they're comfortable with how things are work and that they're going to be in a safe space, and it's just going to be me and them talking, and I'm going to be the one going back and forth and dealing with the other party. It just goes a long way. I mean, I had one where my case manager came back and she was like, she's very interested in the informal, but she's very scared. And so I gave her a call and we talked about it. And she, seemed to really get more comfortable. By the time we actually did the informal, she was like a different person. She came in and she was much more grounded. She was much more able to articulate what it is that this particular person wanted in order to feel safe enough to move forward. And I think it just worked out better because we took care of those anxieties at the earliest possible stage.
Makes sense. You mentioned a little bit about formal. I don't want to dwell too much on the formal process, but I think there is something that's really relevant here, which is similar to litigation. And it's not completely analogous, but I think there are certainly analogies. A Title IX formal proceeding can be long, grueling, can wear on the parties mentally. So in that type of process, how do you make sure that you're interjecting compassion and empathy throughout the process to make sure that there's a level of comfort both in the process and with you? Because like I said, that's just a long and grueling process that really, I think a lot of people who haven't experienced it, it's a very stark reality once they're in the midst of it.
Yeah, that's true. Well, we're going to utilize what we've already discussed in some of those techniques of do it early, do it often. I think just taking the patients to explain how we work, to explain that they're going to be in these safe spaces. I can't stress that enough. And that's why I really like the remote and shuttle, because it creates those safe spaces. Once they're comfortable, then they can start trusting in me, and they can start trusting in the process, and it leaves their attention and energy open, which can then be directed towards a resolution. Empathy and compassion, of course, doesn't end after the beginning stage. So I always let the parties know that if they need a break for any reason, to let me know. I let them know that they're in control. If they feel that this isn't working for them, they can end the session. If we get into a particularly difficult or emotional conversation, I share my empathy with them. And I think this is a big plus here. I oftentimes in the very beginning, I will talk to especially a complainant, and I'll just say, I'm sorry you've had to deal with this. Just something as simple as that. I'm not apologizing, on behalf of anything. I'm just sharing some empathy and acknowledging that this person is going through a difficult time. You can literally see the shoulders, just the breath just drop, like they're exhaling a huge amount of stress, because now they're thinking, oh my gosh, this person actually is sharing empathy with me. This person is actually, giving me a moment to just, be okay with being anxious, right? And so just having this agreement that it's an acknowledgement, right? You can still be neutral when you're doing that, but it's a validation of their very real feelings and concerns. And that leads them to feel heard. And once we start opening that up, then I use active listening techniques such as affect labeling, or reading back what was said for clarity, or reflect, restate, and reframe, which is another way of reading back what they say. And so these techniques have actually been shown to have a measurable biological effect on the human body. It reduces your heart rate, it regulates breathing, it literally cuts off in your brain stress and anxiety and almost like fight or flight. So when you start doing things like affect labeling, when tensions are starting to get high and emotions are starting to get high, it really does calm people down. So ultimately, we want to create this clear space to, get back to what we're here for, which is looking at, can this be resolved? I mean, we have to set forth in the beginning. I should have said this before. I always set forth in the very beginning what our goal is here with anything having to do with Title IX. I tell people, Title IX, at the end of the day, the goal is, do you feel safe enough to get your education? That's like keeping your eye on the ball. And I'll oftentimes refer to that at different points during the process. Maybe we've made a little progress. Maybe we've agreed on some milestone. Then we check back. Okay, we made this agreement. How do you feel? How do you feel about this? Can you look yourself in the mirror and say, I've done something good for myself? Can you look yourself in the mirror and say, I'm on my way to feeling safe enough to get my education, because that's the goal. So that it really helps them stay on track.
That makes a ton of sense. You've mentioned something that I've often thought about in this context, which is I would almost say the dichotomy between neutrality and empathy, right? So if you're expressing empathy, somebody might feel he's on my side, and that's not the purpose of this. You need to maintain your neutrality. So if you could just discuss a little bit about things that you should not say in order to maintain neutrality, even if you want to demonstrate empathy.
Well, that's a great question. we always have to remember that we can show empathy and compassion and respect for the parties without advocacy. And so I just bring it right out in the open very early. I will tell people, I am not an advocate. I'm not on your side. I'm not on their side. I'm not going to make any decisions for you. I'm not going to give you legal or academic advice. I won't speculate what, if anything, a decision maker may or not decide if this were go to the formal hearing. I do talk about the risks of going to a formal hearing and what outcomes might be possible, but I'm not going to speculate with them, because that's oftentimes a question that comes up. And what do you think that's going to happen? I'm like, no, we're not going to do that. So that brings up, I think, a big question of what should a facilitator's role be? Should they be active in providing options for resolution, or should facilitators be stoic and try to be defer anything to err on the side of complete rigid neutrality? And I think I'm of the opinion that we should be active for a couple of reasons. As long as they know that we're not advocating, right? We should be helping them look at what options are available. And we have to understand that oftentimes, both complainants and respondents have no idea what's available. They don't know what are possibilities. So it's our job to show them various ways that we can explore. But there's a fine line between influencing the parties and providing options. So you have to be cognizant. And so again, I'll check them through the process and say things like, remember, I'm going to give the other party this same opportunity. I show compassion and empathy equally here. So we're not taking sides, but we can take a more humanity approach, I would call it, in helping people down the path. I mean, that's what a facilitator does, right? We facilitate, we help people choose options.
Makes sense. I'm going to make sure that we get our 15 minutes in, so I'm going to jump a couple of questions here.
Yeah.
How can you mentioned advocates and advisors? How can you use them to maintain comfort and to an empathetic environment? Or can you, I guess, is the question.
Thanks for
can they
bringing
be
this
a
up.
tool?
Yeah. It's important, again, we allow advisors, but we don't require them here in the informal process. They may or may not be attorneys, but I've had people bring friends. I've had people bring faculty. I've had people bring department heads and also parents, which I've actually really enjoyed. I've had very, very good conversations with parents that were acting as advisors. So, I see the benefits in having someone provide support. I always tell people, we're in these breakout rooms. If you want to privately confer with your advisor, all they have to do is ask. I'll excuse myself, and then when they're ready, they can send me a little chat message and I'll come back in. If there's an attorney advisor involved, I always make sure to let them understand this is an adversarial. We're in a confidential space, so we can talk frankly. Another important thing is I don't share information with the other party unless I'm given permission. So sometimes in the course of discussion, we might bring up some information that might help shift perspectives or provide context. But I still always ask, hey, that's a good point. Could I share that with the other party? And that, again, gives them control. This is a informal process where the parties, maintain control. If there's an attorney involved, I'm always definitely, you gotta be clear with this. You gotta tell whichever party you're dealing with, hey, we can talk freely here, but always defer to your advisor for any advice or counsel. It's not me, it's not anybody else. If you have a question, talk to your advisor. If you want me to step out of the room, I'll step out of the room. This brings down advisor anxiety, because sometimes advisors are just waiting for you to like show some sort of advocacy, or they're going to, oftentimes parties come in again thinking that they're not going to get a fair shake. I tell again the advisors, hey, we're dealing with allegations and not proved facts. I don't have any reason not to believe you as a complainant. I don't have any reason not to believe the respondent. So we're just going to take things at face value and move forward and see what happens.
Makes sense. I know Alex is going to kill me. We're supposed to be in Q&A time. I just wanted to hit one thing because I think it's particularly interesting. You've developed this concept of micro mediations, and you've written about it in Pepperdine's dispute resolution law journal. Can you just tell us very briefly about this concept and why you think it's effective and how empathy can play into it?
Sure. So I wanted to explore the space between, having no action. And in other words, what do you do with the things that don't rise to the level of a civil rights question or a Title IX question? We're talking things like offensive conduct, microaggressions, things like that. So micromediation really fills the gap, and it is super informal. So if you think of a spectrum, with the hearing, the formal process hearing being on one side as being formal, and, no action as being, zero. Micromediation is step one, and then you go to something like informal resolution. And so really it is teaching schools ways that they can maybe train student mediators. I'm a big fan of law school clinics, having students come in and do the ad hoc, like immediate interventions, educational conversations, whatever you want to call it. And really it's just getting the parties to some facilitated dialogue. The difference is there's no expected outcome. There's no agreement at the end or sanctions or anything. It's just talking through these issues that by themselves don't rise to a civil rights level, but maybe they could if they're left to fester, over time. So that's really the gist of it.
Makes perfect sense. Okay, I want to jump into questions. Alex, I know you had a particular way you wanted to handle this. So if you want to unmute and ask the questions that have come up in chat, there's been a bunch of stuff going on. I'm apologizing. I haven't been following that closely. I've been more engaged in this. But however we want to get these questions answered, I would love to get them answered. And just as a side note, before we jump into that, we will make sure we recorded all these questions, and we will get you answers to them, even if they're not answered live.
So I do want to point out that if you want to unmute yourself and ask a question, you're more than welcome to do so. There were two questions that were similar. One, I'll read both of them really quickly, but one was, do you have a script or any standard language you use at the beginning to set the stage during an intake or informal resolution that you would be willing to share, which was similar to, is there a specific language that you use to validate the party's feelings? Oh, I think I'm reading the wrong one, but that's okay. Which I agree is important, but that you can utilize to also remain neutral.
Sure. So our case managers and I have developed some verbiage, I think, that is useful because we offer informal resolution early and often. That's basically our mantra, early and often. The instance of a first report, the first contact with one of our case managers, and they will bring up informal resolution. It really is this quick description of how informal resolution differs from the formal process. That's really the main thing that we need to go through. I don't know, I'd have to check with my Title IX coordinator if I could share the particular verbiage, so maybe Colin and I can work on that, but really early and often, and it's just in detail describing the differences mainly the control aspect, where the formal process parties don't have very much control, versus the informal process where there were parties, retain control and empowerment to make their own agreement.
There was also one sent in before the webinar from Jillian, I believe is how you say your name. And she's asked, can a trauma-informed approach create issues of bias by the investigator, even if the treatment is equal? What can I do to avoid this and make an appeal less likely?
I guess I'm not quite understanding how being trauma informed when dealing with somebody can create a bias or be grounds for an appeal. I mean, and I guess if you get 10 people in the room and ask them what trauma informed process is, you're probably going to get 13 different answers. But I think at the beginning, case managers are a lot differently, because they're dealing with the actual allegations, they're doing intake reviews, they're going through, what is alleged to have occurred. By the time it gets to me, it's been, talked about that informal isn't the place to try to prove your case, right? And many complainants don't choose informal resolution for that reason, that they want to prove that something did or didn't happen, right? Or somebody did something. It's really allowing the complainant to choose how what their needs and wants are, because oftentimes a complainant will say something like, yeah, I went through a very horrible thing, but I'm not interested in going over these things. I just want X, Y, and Z in order for me to feel safe enough to get my education. Well, now we're dealing with something that we can talk about in informal resolution. And so there's not a lot of, I guess, worry for me in the informal process of crossing any bias lines by being empathetic or compassionate to somebody in regards to their trauma.
Catherine Webster was raised her hand to ask a question.
Yes, thank you. So my question was, I know that you had mentioned early in the presentation about the creativity with the informal process, where it allowed some complainants to cater the approach, whether they wanted to be more restorative or potentially punitive. And I was curious as to what that looked like, as from my experience, the informal, there's not, because both parties agree upon it, as you say, the informal doesn't typically have a punitive aspect because they're not assigned a responsible finding. So if you wouldn't mind sharing some examples of what that might look like for complainants in more of what that punitive aspect would be for some of the individuals who have done informals with you.
That's a great question. And I think that's one of the biggest persistent myths about informal resolution, is that somehow that justice isn't going to be done, that there's not going to be potential punitive outcomes. And that's just absolutely not true. And that's also one of the reasons why many schools do not feel comfortable having like sexual assault cases or rape allegations done by informal resolution. I mean, there are certain things, obviously, that the Title IX coordinator is going to determine what's reasonable. Like any kind of violence, physical violence is definitely not coming to informal resolution. But oftentimes a complainant, even with a very serious allegation, will tell us, I don't want to subject myself to the coercive formal process, and I want something punitive as an outcome. And I've negotiated withdrawals from the university, permanent withdrawals, multi-year suspensions, loss of leadership positions in student government and the Corps, monetary restitution. all kinds of stuff. And that's really where creativity comes into mix, because we have to understand in the formal process, at least here, I don't know how other schools do it, but in the formal process, the only thing on the table is did they or did they not violate your university's policy regarding civil rights? And if so, how should they be punished by the university? That's it. That's all it is. On the informal side, almost anything is on the table. And so why would a respondent agree to something like this? Well, and this is where attorney advisors are very, very helpful, because they can talk sense into their advisees. We need to look at the potential risks of going to a formal process. So it could be like, hey, look, here's what's on the, if you've got a sexual assault with incapacitation, okay, that's an aggravating factor. You are probably, if you're found in violation at a formal process, we don't know how it's going to go, but if you are found in violation, you will likely be expelled. That's just the reality of it. So this complainant may say, you know what, if they voluntarily withdraw and if they agree to X, Y, and Z in order to make me feel safe, that's what I want. That might be a good deal for the respondent. And oftentimes their advisor is going to say, yeah, you want to take that one and run. Because it's a certainty of outcome. They know what they're going to get versus flipping the coin, going through the formal process and losing everything. Conversely, I have to tell the complainants, hey, look, we never know how things are going to go. I don't know what's going to come up in an investigation, neither do you. After all of the evidence has been sifted through and the witnesses have been interviewed or whatever, the decision maker might come up with a decision that you're not happy with. So oftentimes that is why complainants then will appear to be flexible. But remember, it's not what I think should be done. It's what they think. As long as it's reasonable to the school, because the school's got to balance the safety of the community at large, right? We're not going to have some terrible like domestic violence case go with and even if both parties agree, if the outcome isn't safe, we're not going to agree. We're a party to this, right? I have veto power. I can say, no, that's not reasonable. But the complainant might say, this agreement allows me to feel safe enough to get my education. And if that means them allowing maybe a non-traditional type of outcome, as long as everybody's in agreement and it passes our Title IX coordinator review these things and our risk management executive reviews these things, if everything's reasonable, that's their agreement. They made it.
This is great. I hate to cut us off. We're at the hour. I want to make sure that we open up networking. There's a couple of things that we do want to talk just very, very quickly about. I'm going to turn it over to Anthea. We are doing a Title IX mediator training. So I want her to talk just a little bit about that.
Yes, thanks, Colin. So I'm the customer success manager here at New Era ADR, and I wanted to mention that we're always looking for experienced, diverse neutrals to add to both our Title IX bench and our commercial bench. We do, as Colin mentioned, offer some Title IX trainings through a third party. And if there's any interest, please do let me know. In the follow-up email, Alex will include a document outlining the minimum requirements for joining our bench. And, feel free, if you're interested, to take a look and reach out to myself or Colin if you have questions or interest in that.
That's perfect. And in addition, in the follow-up email, we have, Alex, correct me if I'm wrong, the alias is title9@neweraadr.com. If there's questions that you want to get answered, if you could submit those to that alias over the next day or so, we'll make sure in the follow-up email that we get as many answers as possible out of Joe. Thanks, Joe. To you guys as possible. And in addition, just, gratuitous plug for New Era. We're very interested. We have a super trained bench on this and a platform that handles everything virtually. If you are under-resourced, if you feel like you don't have the bandwidth, if you need help, we can help with these things and we would love to help. So if that's of any interest to you, please contact us. Alex is now to explain how we're going to open up networking, and we will let everybody talk amongst themselves. Thank you guys so much for joining this. Thank you to Joe for doing this. It was fantastic. Tons of knowledge, tons of interesting stuff. So once again, thanks everybody for being here.
Thanks for having me.
So I was thinking that we can leave the meeting open for as long as you guys would like to be here. So if you want to talk amongst each other, and feel free to chat with one another.
I'll try to stick around for a little bit in case other people want to ask some questions.
Yeah, that's great. And if there's any questions for us at New Era, we're here too. But nobody's obligated to stay. It's just an open forum for anybody who wants to ask questions or learn more.
And thanks for the questions too. They were very good. So what some of the questions in the chat that we weren't able to get to, you know, Alexandra, maybe you can compile those and we can try to answer them.
Yep, I copied them so we can send them answers. So we won't leave them hanging, if you will.
Sounds good.
Hi, Joe. My name is
Hi.
Greg. Just a quick question. I'm a new Title IX investigator up here at Holy Cross in Worcester, Mass. Started in early December. I was just curious why you were referring to the formal process as coercive.
Well, because there is that element of they don't have as much power, right? They don't get to direct how things go. The university is taking the investigation and taking the hearing and how wherever that leads, they're going. They don't, you know, they're kind of along for the ride in that respect. A lot of the times people feel that being, you know, interviewed and direct examined and cross-examined is coercive, and it's very stressful and very, very anxiety producing. And I can't tell you how many times I've had complainants tell their case managers and tell me, I am absolutely not going to do that, but I still want an outcome that I can live with. And so that's where we do our best to try to deliver those outcomes without having the parties have to go through that formal process.
That's helpful. Thank you.
Thanks, Gregory.
Yes, have a great day.
Hey, Joe, this is Amber Morgan at Transylvania University. If you don't mind, I have a quick question for you.
Yes.
Thank you. First off, thank you so much. Your information was extremely helpful. I messaged you while you were talking. So I recently, I'm a Title IX coordinator, and I recently worked to mediate an informal resolution, and it was a sexual assault case. And it was, this was a situation where the respondent had a very aggressive attorney and would not agree to any of the punitive measures that the complainant had put forward. And the complainant, you know, did not want to go through hearing, was adamant that, you know, that was not going to happen. She did end up resolving informally. They both agreed. I felt personally very uncomfortable with what was agreed upon in the mediation, but I know it's not about me and what I would want. But it was just a difficult situation. So, I mean, just some thoughts on, you know, this was really a case where I felt like the respondent was also getting some really bad advice from their attorney, because there was quite a bit of evidence to show. I personally felt that if it went to a hearing, they would have been found responsible. And they just were refusing to accept any punitive measures because they felt like it was an admission of responsibility. So maybe just your thoughts on how to handle that if it ever comes up again.
Yeah, boy, I've certainly dealt with that, especially when there is potential criminal concerns. As we know, any kind of sexual assault or domestic, issues like that, just because there isn't an active criminal component doesn't mean that there can't be one in the future. So I've definitely had respondents, attorneys saying, hey, look, we want to give the complainant, as much as we can, but we can't admit to something that could be seen as a legal admission in writing, right? That's a very valid concern. And so thankfully, both sides had attorneys. So we were able to have frank discussions that I would say, okay, this is the respondent's concern. It's a valid concern. What is important to you as a complainant? Do you want them to take responsibility on paper? If so, maybe informal isn't the way to do this. Maybe we need to go to the formal process, and then it's all about getting found responsible for a civil rights violation and having that be in writing. But you also have to take the risk that it may not come out the way you want it to come out, right? Conversely, if it's not important for the complainant that there's some sort of responsibility on paper, and oftentimes there isn't. Remember, when I take people back to what's the goal? The goal is for you to feel safe enough to get your education. What does that look like to you? Oftentimes when they're allowed to articulate that, it is, well, I don't want this person on campus, or I don't want this person being able to come to my housing unit. I don't want them taking the same classes. I want them, out of my, schedule, so to speak. There might be other things that the complainant actually wants and needs in order for them to feel safe enough to get their education. So that's kind of a way where we've negotiated where there might be a finding of no responsibility or even a withdrawal of the complaint. So there's nothing that could be seen as a legal admission, but that doesn't mean there wasn't punitive sanctions. I mean, I've negotiated where a complaint was withdrawn, but the respondent voluntarily disenrolled from the university. That, to the complainant, was what they wanted. They wanted this person out of sight, out of mind, don't ever want to run into him again. So we were able to come up with an agreement that kind of met both people's needs and wants as closely as possible. If you get a very adversarial attorney, and maybe this is where having some legal experience is good, but I'm not intimidated by attorneys, and I will sit them down and I will tell them, we're not here to be adversarial. If you want to try this case, do it in a court, go to the formal process, but here's the risks. I call it the come to Jesus talk. Here's the risk that your respondent is taking by going to the formal process. Don't forget, the respondent is the one telling their attorney what may or may not have happened. So their version might not be, accurate. So I've had to stop a session in the middle of a session, go to my Title IX coordinator and get permission to share some evidentiary items that we had that the respondent and the respondent's lawyer didn't know we had. Maybe there was text messages, maybe there's photographs, and say, I know something you don't know. I don't know how this would play out in a formal process, but here's what we're dealing with. Now, do you want to change your adversarial tone? And that worked. Then they said, oh, let me talk to my client. 20 minutes later, they came back and now they were all willing to negotiate.
Yeah, in this particular instance, there were actual text messages of admissions of what the complainant said happened. And I did share that with the respondent and the attorney, and it was still a no. Yeah, no, absolutely not gonna agree. I mean, they agreed to hardly anything, and it was just personally difficult for me because the respondent was a resident advisor. So to me, I felt very conflicted in having them remain in their role.
Yeah,
But the school was okay with it.
yeah, that's an interesting one. Did it have to do with an insistence on them taking responsibility for this particular issue or allegation on paper? In other words, we have our system regulation 080101, which is our civil rights code here. And so, yeah, oftentimes an attorney will tell the respondent, you can't accept that responsibility because that could potentially open you up to civil or criminal ramifications. But if we take that off the table and there isn't a finding of responsibility, that doesn't mean we can't have punitive outcomes along with it, because it's by agreement. And oftentimes, again, it's a risk analysis that everyone has to do. What are your chances? Because if this goes to a formal process, formal hearing, what do you have to lose should you get found, in violation? And sometimes you're going to get against a hard case and they don't want to, negotiate. That's kind of a tough one.
Yeah,
we would basically default to the formal process anyways and deal with it that way.
So you're saying that there's a possibility you negotiated a case where the agreement was a respondent, if a complainant withdrew the complaint, the respondent would withdraw from the institution?
Oh, absolutely.
Okay.
I've had them pay large cash restitution to, let's say, pay for therapy. I've had them take, multi-year suspensions, and then they have to petition their way they basically at the end of this 3-year suspension, you have to petition the Title IX coordinator for the opportunity to apply to come back, which is in effect, a voluntary disenrollment. I've had people voluntarily disenroll because that's on paper, not an expulsion. So that is a benefit to that respondent, even though they're taking a huge hit, it's still a benefit. It's risk management for the respondent. And as long as we can, balance it with the safety and well-being of our campus at large, we're going to look at it. Some offers do not meet that balance, and we veto them. We just say, no, that's not reasonable. We're not going to do it. If there's a particularly egregious case and even if the parties agree, oh yeah, there's going to be no finding and you're placed on maybe just a very light probation. No, that's not going to work. We'll veto that. But if there's a punitive outcome and it makes the complainant feel safe, do we really need to get them on paper that they're in violation? I don't think so.
Yeah, that's true. Thank you.
Joe, quick question. Dana King asked this, and this is particularly interesting to me because of the amendments that may be passed, whether it be April, May, or whatever. But Dana asked, you mentioned facilitating micro mediations when conduct may not reach a civil rights violation. But with the 2020 final rule, my understanding and my institution's practice is that we have to have a formal complaint to start any kind of informal resolution. How do you initiate those? I often feel like our hands are tied when the conduct does not rise to a policy violation, but is concerning.
Yeah, so micromediation is not just for a Title IX office. It could be used in any type of educational setting. It could be a faculty member in class sees a disturbance between two students. Maybe some offensive language is used, maybe some racially insensitive words were uttered. Does that necessarily rise to the Title IX level? No, of course not, because there's freedom of speech, no matter how obnoxious or hurtful it may be. Depending on your school's student conduct code, and I don't know how you deal with that, but micromediation would be a way to facilitate some dialogue in lieu of a formal Title IX complaint. Now, with the new Biden proposed regs, where we can do an informal without a formal complaint, that kind of opens up that possibility for Title IX now. But in a overall sense, I don't think there's anything stopping a school from getting two students, pulling them out of class and saying, you need to go talk to the student mediator right now, and we're going to work through this issue that you're having. That's really where micromediation is going to come in. But I do think that the new Biden regs are going to see a very big uptick in informal resolutions because of the ability to offer them before even we get into the process with a formal complaint.
Okay. So I think that's it, unless anybody has any other questions. Once again, thanks everybody for being so engaged. Thanks, Joe, for doing this. And we'll have more content and stuff, but there will be a follow-up email coming out that will answer any missed questions and give everybody some more information. So once again, thanks so much, and everybody have a great week.
All right. Thank you all. Appreciate it.